you seem like you're in love with him, but you love Ryle. And I was like, no, I also love Ryle, but like, I really love Atlas. He's like, you love Ryle. And I was like, wait, I'm sorry. Oh, wait, what's happening? But you love Ryle. I do, but like, she's conflicted.
Totally.
And that was always an interesting dynamic when you have somebody who's playing the character also being the one like looking at the movie. So we were always like, are we too connected? Are we too vibing?
Yeah.
But she loves Ryle. He's the best. I mean, she loves Atlas. She also loves Ryle. But she loves Atlas and young Lily.
Hi, besties. It's Katie from Without a Crystal Ball. Welcome back to my channel. Well, there's finally some good news. After a string of hits where everyone thought that Blake Lively was never going to get held accountable and that Judge Lyman was in her pocket. I mean, come on. We still think he's kind of in her pocket. Let's just be honest. But Jed Wallace has been dismissed from this lawsuit in New York under the grounds that the state of New York and Judge Lyman in Federal District Court of New York lacks the jurisdiction over Jed Wallace as a resident of the state of Texas. And in this ruling, which I found was interesting, is that he made some notes about some of the actions that Lively claims were taken against her in New York. And he teases through these claims, and it will, truthfully, it kind of weakens her case against some of the other people involved in this case. So and he almost seemed a little bit puzzled that Baldoni and Heath and Sarowitz and Nathan and Abel didn't actually dismiss the case for personal jurisdiction and have it done in California simply because they live in California. And he said that she has cited nothing that happened in New York that directly harmed her reputation in New York. It's pretty wild. So anyways, he says that it's granted for lack of personal jurisdiction without prejudice. Now, some people, I've already shared this on my Instagram, have already expressed some frustration about the lack of between without prejudice and with prejudice because of how Justin's case was dismissed. But to be clear, motions to dismiss when they are around the grounds of personal jurisdiction are almost always dismissed without prejudice simply because they can then take the case and then file it in the proper venue. So she can go to Texas and file this case in Texas against Jed if she wants to. She has to make that decision if she wants to split the case that way. But her case, he dismissed it based on litigation privilege. And so he cited it with prejudice because under his arguments in his order, he said that everything that happened occurred within the construct of litigation or on the verge of litigation. So she had the privilege of litigation in the CRD, and she had privilege within her complaint with the court. So there's that. Completely different options. So the without prejudice just means she can go to Texas or she can amend here, but he doesn't think here's the proper venue, even if she had evidence, which he doubts she has. In this motion, he goes through like the whole background of the case, and I'm not going to do that because all of you guys remember what's happened in this case. Obviously, you know that she's alleging this alleged smear campaign. She's trying to tell the court that Jed's involvement here was that he was hired to have like this digital army do work for him in the state of, to smear her, and that it was part of this retaliation for her speaking out against sexual harassment that she claims was brought up back in May of 23. And she claims that this all happened then because the movie came out and suddenly she got all this negative feedback on social media. Now, interestingly, he notes in this, the negative media and social media coverage spiked on August 8th and August 14th. Lively was criticized for the way that she was marketing the film being a bully and mean girl and allegedly marginalizing Baldoni from the film. Lively's businesses experienced a dramatic drop in sales and were forced to go dark on social media due to overwhelming negative comments. And that's not even true. They're not dark. She still promotes on those. She suspected the rapid shift around the time of the film's release was orchestrated by Baldoni and Heath. And then he says that it again spiked when she filed the lawsuit. And she alleges that when she announced a new movie, they got even worse in February 4th. And she's claiming that this is all being originated by Wayfair's smear campaign and that they're continuing to pursue this untraceable digital social media manipulation campaign designed to impact social media algorithms against Lively to this day. And that part of it's going to be ridiculously hard for her to prove because now people are reporting on public documents like what we're doing right here. So he takes into account that he provided a declaration and that Wallace is a citizen of Texas, domiciled in Hayes County. It's incorporated in California in 2008, but was then incorporated in Texas since it was joined as a defendant in this case. He's the only officer, director, or employee of Street Relations, and the corporation's principal place of business is in Texas. And neither Wallace or his business have any property in New York. He says that he was hired by Melissa Nathan in August 24 to read, analyze, and assess media trends related to Justin and potential stories or social media attacks on him. He reviewed all forms of media, analyzed the sentiment of the coverage, and made comments mainly to Nathan. He saw the people on social media organically supported Baldoni and disliked Lively. Therefore, his advice was not to do anything at that time. And he concluded work related to Baldoni in November of 24. He has an understanding of social combat and social manipulations could be, but he did not provide that service related to It Ends With Us, Wayfair, Baldoni, or Lively or Reynolds. He did not publish directly or indirectly any information or content about Lively. He also did not direct anyone else to post about them, like or comment any social media posts about It Ends With Us or anyone else. And he did not cause to provide journalists or content creators or other media entities anywhere, including the New York Post or New York Times. He does not have a digital army in any location and does not have direct or work with a team in Hawaii. He states that his role was merely passively to observe the analysis of the social media environment. He also cites that he's been to New York 4 times since 1991, and all the work concerning Baldoni and Wayfair was done in Texas. And he understood himself to be providing services to people in California. He then goes through the procedural histories, and then he cites that on June 26th, the court ordered supplemental briefing on the Wallace defendant's assertion that Lively never identifies any specific co-conspirator committing any specific act that qualifies under 302A, an act taken while physically present in New York, that she's seeking to impute to Wallace through the conspiracy theory jurisdiction. So he then discusses like what the legal standard is and all of this. So then he gets into why he's going to dismiss the case. He says that Wallace's motion to dismiss must be granted because the court lacks personal jurisdiction over him. Personal jurisdiction is a claim specific and defendant specific. It ensures that there is a connection between each defendant being sued and the place that defendant is being sued. So the defendant is not forced to litigate in an unexpected and faraway forum. Lively's case against other defendants will proceed in this court, but the Wallace defendants are located in Texas, and Lively has not alleged that they are responsible for any act that would subject them to jurisdiction in New York. The alleged negative publicity campaign against Lively largely took place outside of New York. The few alleged actions targeting New York were taken by others, and there are no allegations suggesting the Wallace defendants were aware of them. Therefore, the Wallace defendants cannot be forced to defend this lawsuit in New York. If she wishes to pursue her claims against Wallace, she must do so in another forum or replead her complaint to allege jurisdiction over the defendants in this forum. I do think it's a little bit odd that he's allowing her to like replead if she has jurisdiction over him in New York because there's no evidence that this happened. And she claims that she could provide evidence, but at the very end of this, he says that he doubts that this evidence even exists because if it did, she probably would have provided it to the court or included it in the complaint. And he also noted that discovery is nearly complete. And so if she had this evidence in discovery, it would be reasonable that she would have brought it up at some point in time to this court, and she has not. He then goes on to share that, Blake doesn't think that they should be able to take his declaration submitted by Wallace into account, but they can consider affidavits and other materials beyond pleadings when assessing a motion to dismiss. They can't discount her allegations submitted in hers, but they're allowed to, if he has something to share to show where he lives, they can consider it that. So I had a feeling that the declaration would be taken into account. He says, therefore, while the court may consider Jed Wallace's declaration, it may not credit it over conflicting allegations in the pleadings without holding an evidentiary hearing or ordering jurisdictional discovery. There is no need for such procedures here because, as discussed below, even assuming the truth of the allegations in her complaint, they do not establish jurisdiction over Wallace. And then he goes into the different state laws about jurisdiction and then what the state law is for New York. And then he goes over what the requirements are and what they are under the legal standard are the person has to transact business within the state or contracts anywhere to supply goods or services. They commit a tortious act within the state, except as to a cause of action for defamation or character arising from the act, commits a tortious act without the state causing injury to a person or property within the state, except as to the cause of action for defamation of character arising from the act, regularly does solicit business or engages in any other persistent course of conduct or derives substantial revenue, and expects or should reasonably expect the act to have consequences in the state. And he does say that she does not argue that Wallace defendants themselves had contacts that would satisfy this, nor could she. The Wallace defendants are not subject to general jurisdiction in New York. He resides in Texas. His company is incorporated in California with his principal place of business in Texas. There's no factual allegations either the Wallace defendants transacted any business in New York or committed torturous acts within New York, so to establish specific jurisdiction based on the conduct of the Wallace defendants in isolation. And then he goes on to say that the amended complaint does not allege that the Wallace defendants' torturous acts caused injury to her in New York. Plaintiff has not alleged any facts regarding the Wallace defendants' general course of business or revenue. And then he brings up that she's using this like jurisdictional conspiracy jurisdiction theory, but he says that again is not relevant to her. I think it's interesting because when you do look at the complaint and when you're reading through it, I remember first thinking, why was this filed in New York? I think we know now the reason why it was filed in New York was because the evidence that she obtained through the sham Van Zandt action, where she got Jen Abel's phone, was through a New York subpoena. It wasn't through a California subpoena, which has stricter rules about notifying people that are being the targets of a subpoena. So in the state of California, say you do an employer is subpoenaed for your records under the law, that employer, even though you're not the direct target of it, has to notify you because it's your information they're after. The same thing with Google. So because Google is domiciled in California, under the law, they have to provide notice to any person that might be a target of a subpoena that they receive, even if it's done out of New York. But with her Van Zandt action, right, she got it without notifying Jen through a sham action that included a shell company. And so because of that, she can't go to California and file this lawsuit in California because she would then have to domesticate the subpoena there, which would have then given notice to Jen Abel, who could have objected under privacy concerns or had an opportunity to get the subpoena quashed. And we've already seen that in this case, the judge, had she gone through the proper channels to get Jen Abel's phone, it would have been quashed. She wouldn't have been allowed because he quashed her subpoenas for phone records for the same information. The judge notes that the arguments made by the Wallace defendants were very persuasive, especially about the jurisdictional conspiracy, the conspiracy jurisdiction theory that she's trying to use to have him situated in New York under the jurisdiction of New York. Because they say the Wallace defendants argue that this understanding is not consistent with more recent New York cases requiring that the out-of-state defendant have some extent of control over the in-state actor in order for contacts to be imputed. This argument has some force. The concept of conspiracy jurisdiction derives from the New York Court of Appeals holding in Kreider versus McFadden Oil Company that the words through an agent does not require a formal agency relationship, but may be satisfied by the fact that the agent engaged in purposeful activities in the state for the benefit of and with the knowledge and consent of the non-domiciliary defendants, that they exercise some control in that matter. When conspiracy is not invoked, case law generally holds that some control is necessary to satisfy the agency language. And as far as he's concerned, he says that the New York Court of Appeals has not addressed the issue. The Second Circuit has predicted that if it did so, it would follow Lottie in holding that the control prong may be satisfied by an allegation that the out-of-state defendant was aware of the torts being committed by co-conspirators in New York. And he argues that in order for her to be successful, Jed Wallace would have had to have been aware of actions that were taken and that the actions were in the benefit of Wallace. And he says that she fails on that threshold because she has not alleged any co-conspirator performed overt acts in furtherance of the conspiracy while the co-conspirator was physically present in New York. The amended complaint alleges a number of actions and communications that formed the conspiracy to damage the reputation, but not any of them took place in New York. I still, to this day, wonder why Wayfair went to New York, maybe for ease and to consolidate, because maybe she would then say, like, you have no jurisdiction over me in California, even though the contract stated that everything would be done under California law. But it is odd that New York was chosen because the film was filmed in New Jersey, and then editing of the film was done in California, and there was only a few things that actually happened in New York, like the premiere, and then, he went to her loft a couple times or her penthouse, but even then, that has nothing to do with the smear campaign. Like, things that happened during the film have nothing to do with the conspiracy of a smear campaign that happened months and months and months later. For example, he says Lively alleges that certain co-conspirators took actions within New York during the filming of It Ends With Us. But these actions were not within the scope of or in furtherance of an alleged conspiracy to retaliate against Lively, which did not begin until after filming ended. So everything that occurred before filming ended, he says, is not part of a conspiracy to ruin her reputation. And that seems to be kind of an indication that that part of her case is weak. And I think part of that is why she's relying so much on the smear campaign, because everything that happened with the harassment, the alleged harassment, I should say, doesn't directly meet, like, she has to prove that they were doing these things because she spoke out. And finding out that she was having complaints doesn't mean a conspiracy happened at that point. The amended complaint alleges that Nathan lived in Brooklyn during a portion of the relevant period, but she does not, like, specify the relevant period or any actions that Nathan took in New York in furtherance of the conspiracy. The fact that she lived in New York at an unspecified time over the course of the conspiracy does not itself give rise to the inference that she took an action in furtherance of the conspiracy while in New York, particularly when she also resided in California and was working with others who lived in California and in Texas. And then this part I thought was interesting. He opines about what Sorowitz said about her at the premiere. Lyman writes, the amended complaint alleges that Sarowitz threatened to ruin the lives of Miss Lively and her family while attending the film's New York premiere. However, Lively has not alleged facts showing that this was an overt act performed by any co-conspirator for the purpose of accomplishing the objectives of the conspiracy. A conversation may constitute an overt act in furtherance of a conspiracy, but only if it tends to carry out the object of the conspiracy. Mere conversations between two co-conspirators about the conspiracy do not suffice. Here, there is nothing to suggest an inference that Sorowitz was attempting to recruit a co conspirator trying to cause lively distress or taking any other action in furtherance of the conspiracy. He simply stated to an unidentified witness that he was prepared to spend money to harm Lively. This statement describes the existence of a conspiracy, but there's no basis to infer it was intended to advance the conspiracy. And truthfully, we don't even know what context that was. Like, if they're being threatened to be sued, it could be spending $100 million to defend his faith, which is what they've said is what he said. And we know that Blake lies about everything. Moreover, assuming that Nathan or Sorowitz took actions in the New York in furtherance of the conspiracy, Lively has not shown that such acts may be imputed to the Wallace defendants for jurisdictional purposes. Wallace defendants are not alleged to have been in close contact with Sarowitz, and there's no reason to infer that they would be aware of statements he made when they were not present and several days before they were allegedly hired. Even cases which have not required a showing of control over the co conspirator have made it clear that awareness is required. So the fact that him saying something that he's going to spend money isn't proof that he's going to do anything, and Jed has to know it happened and it didn't. He also sort of said that Blake Lively's amended complaint did not establish jurisdiction over him with contacts. Like, she couldn't prove that he had contacts with anyone in New York, and it did not clarify her theory of jurisdiction over Jed Wallace, and her opposition briefing entirely failed to address the long arm statute. And they said the Wallace defendants vigorously argued against the imputation of other defendants' contacts to them as a general matter. And they cannot be faulted for failing to specifically address a novel theory that Lively had not yet raised. And then, as far as the conspiracy based theory of jurisdictions, he says New York courts have never recognized it, ever. So it's not something that they would take into consideration. So it's sort of moot. For example, he says, assuming without deciding that the defendant can be hailed into New York court based on conduct by a co conspirator outside of the state would give rise to 302A1 personal jurisdiction. But Lively has not alleged any such conduct by a co conspirator of which the Wallace defendants had knowledge. She alleges that part of the efforts to bury Lively, Nathan, Abel, Wallace, and Street relations targeted New York by, among other things, communicating with journalists, content creators, and media entities based in New York, including at least one journalist at the New York Post and another at the New York Times. This is supported by specific allegations that Abel and Nathan communicated with Nathan's sister, Sarah Nathan, a journalist at the New York Post and Page Six, on multiple occasions to shape coverage and contribute to the stories that were eventually published. They might support jurisdiction over Abel and Nathan, even if those two did not engage with their conduct from within New York. Over and over, he just says that she fails to prove that anything happened in New York and that Jed Wallace had any understanding that anything was happening in New York, and he didn't communicate with anyone in New York. Lively has not alleged facts that would show the Wallace defendants were aware of those jurisdiction contacts. So if Abel and Nathan were speaking to someone in New York, he didn't know. And then the alleged complaint alleges that Wallace was generally in contact with Abel, Nathan, and Tag, and that they worked together to suppress negative content about Baldoni and amplify negative content about Lively. He notes that the Wallace defendant suggested that the plaintiff's remaining claims for false light and aiding, abetting harassment and retaliation therefore should be subject to stricter jurisdictional standards because she did not establish jurisdiction over Wallace. Here, in any case, the court need not decide whether the allegations against Nathan and Abel are hypothetically sufficient under 302A1, an issue with which both parties have largely failed to address. So, to me, what that signals is that he has concerns that he has jurisdiction over a lot of parties in this case, and that had they done a motion to dismiss, he would have been able to review whether or not they actually had contacts in New York and if anything occurred in New York and that harm was directed at New York towards Lively. And I've said all along, I don't think the proper venue is New York, even under diversity jurisdiction. But since they are willing to move forward, he'll take the case forward, right? But that doesn't mean they couldn't have filed a motion to dismiss. And most importantly, he says there are crucially no allegations that Wallace was aware of Nathan and Abel's contacts with Sarah Nathan or any other actions targeted at New York. Even if imputation of contacts on theory on conspiracy could theoretically satisfy the theory of jurisdiction, no such imputation can occur here. And then with regard to due process and the jurisdictional conspiracy, he opines that the individual has to know that the conspiracy existed and that the defendant participated in it and that co-conspirators' overt acts in furtherance of it had sufficient contacts within the forum state to subject that co-conspirator to jurisdiction in this case or in the state. And his opinion here is that the conspiracy theory would not get off the ground if a defendant were altogether blindsided by its co-conspirators' contact with the forum. So Jed says that he didn't know that anyone was in New York, and so therefore he can't be held liable or responsible for things he did not know to prove that this court has jurisdiction over them. As stated above, the amended complaint contains no factual allegations that the Wallace defendants directed or controlled any conduct into New York or were aware of any actions taken in New York or directed at New York. This lack of control or awareness is fatal due to the due process clause, just as it is under CPLR. A defendant cannot reasonably anticipating being hailed into a court as a result of contacts that are unknown to him. And then he then argues that Blake wanted to do jurisdictional discovery. And he stated that jurisdictional discovery is not necessary or appropriate, given that Lively has not alleged any action by anyone in the conspiracy within New York or any contacts with New York whatsoever that the Wallace defendants were aware of. She has not made a sufficient start towards establishing personal jurisdiction. Moreover, if relevant jurisdictional contacts occurred and Wallace was aware of them, this information is connected to the merits of Lively's claims and would logically be revealed in ongoing document discovery from Wallace and his co-conspirators, not separate jurisdictional discovery from Wallace. The substantial completion deadline for such discovery has already passed. In recognition of the possibility that jurisdictionally relevant facts may be revealed or already have been revealed in discovery, Lively shall have leave to amend her complaint limited to the existing claims alleged against the Wallace defendants. So essentially, what he's saying is that she presented no evidence that he knew anything about New York, that he was doing anything towards New York. And the only way that she can amend and try to go back in New York and get him in this case again is if she can provide discovery and relevant facts that prove that this court has jurisdiction over him. But every single thing that she has told the court thus far doesn't prove, one, that he had any awareness of it, and any incident that she claims happened within New York has nothing to do with Jed Wallace that he was aware of or that he was even involved in it. And her complaint as is really lacks any proof that anything actually happened in New York, which again kind of begs the question why they didn't do a motion to dismiss her claims. But, you know, I am not a lawyer. I don't make those decisions. But I think to sum this up, my big takeaway from this is that much like what he said with Justin is like, just because someone says something doesn't mean it actually meets the standard of causing harm, right? So in relation to Sarowitz, just because he says, I'm going to spend 100 million, doesn't mean that that's going to be proof that he did anything. She has to prove that he used that 100 million to ruin her. And that would not include defending against a lawsuit. That's using legal fees and spending on lawsuits is not proof that you're spending money to ruin something. And the lawsuits themselves are not proof of a retaliation campaign. But that's how she's trying to prove the ongoing smear campaign. So because people reported on his lawsuit, we are part of that campaign, apparently, under her delusions. And as I think my biggest impression as I was reading through this is that I had a feeling that he was going to get dismissed based on jurisdiction alone, right? But I'm noticing that some of her arguments just don't have a lot of teeth and could be a sign that the judge doesn't totally buy some of what she's saying, because part of her argument for conspiracy for all of them is that it started in May of 23 and continued till today, which doesn't make sense. Why would they plan an alleged smear campaign against her almost 2 years after she brought claims, or 18 months after she brought claims against them? It really makes zero sense. And it doesn't prove a conspiracy even exists. So for now, the only way that she can come back into New York is to try to prove that he knew and did something in New York, and the contacts he had with New York involved him and he was aware of it. Okay. And I think that if she would have had that evidence, she probably would have already shared it. I think if she wants to refile, she can go to Texas. And then if she goes to Texas and refiles against him, that's going to almost remove her motion to dismiss against Wallace, right? So she can't um, file in Texas because she has a pending motion to dismiss there. And if she does, then she's availing herself to the jurisdiction of Texas by saying, I'm filing the suit here and I'm letting the court have jurisdiction over me. She's on an uphill battle with Jed, and his removal from this case with, and if he's not re-added, and I just don't see that he will be, and even if he is, she would have to then survive another motion to dismiss against him. And I just don't see them having any evidence against Wallace. And with him out of this case, a lot of that conspiracy argument just completely falls apart because, again, she's claiming that Wallace was an integral part of the damage against her. And yet now she can't have him as a party of this lawsuit. And if he's the one that was orchestrating the smear campaign, how do you then prove that a digital army was doing anything if the court has no jurisdiction over him? And this court even says nothing that he did even took place in New York. It's an uphill battle for her. And I think this motion to dismiss really does show the weaknesses of her case. So I'm not surprised by this. We'll have to see if she decides to amend. She might not. And then even if she does amend, she'll have to, again, overcome another motion to dismiss. I think this is a solid win for Jed. And I think Blake has a decision to make. And that might be that she withdraws her motion to dismiss in Texas and just fights him there, or she just gives up on Jed altogether. Because her case against Jed is flimsy, much like her subpoenas against content creators. So for those of you that are disappointed that Lyman's constantly handing wins to Lively, this is an indication, at least a little bit, that some of her claims, he's seen them for what they are, as flimsy and lacking any real standing. He didn't have to go through the failure to state a claim, but I really do think if he would have used that as the means to dismiss the case, some of her claims would have fallen apart even further. So are you happy about this? Are you not happy? Let me know in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed. And don't fear about your contacts being, or your bank accounts coming from my YouTube channel and from my subscribers. The subpoena thus far that I have received is for my information. I am the subscriber that they are after, and it's my bank account that they are after. So fear not. And if you are concerned about your subscriptions being available to YouTube, you can always set your privacy standards on your subscriptions to private, and then YouTube doesn't share it with anyone. So make sure to give this video a thumbs up. Make sure to subscribe, and please, if you would like to support the channel, make sure to send super thanks, comment, and share with friends. Help us get out in the algorithm. Thanks so much for watching, everyone. Bye, besties.